Well, I'm going to try this again, guys. I don't know what's going to happen, or if anybody will know or care. I apologize.
You get to use your common sense. Every single day in
Thanks,
courtrooms
Joey.
around the country, we convene ordinary people and we ask them to use their common sense about what is reasonable and about what is appropriate and what evidence is proof beyond a reasonable doubt. For about 6 weeks, Ronan Ferriter was locked in a room in Florida. And yeah, he got to go to school, and sometimes he got to go on a scooter, and sometimes he got to play with the dog. But as you heard from Dr. Meyer, that doesn't change the impact of this type of treatment has on any child, but absolutely on a child like Ronan. The defendant's intentional, repeated acts caused harm. Any person would know, any reasonable
I will,
parent
Jovi. I'm
would
sorry.
know
I was
that this is not
panicking,
acceptable.
trying to figure out what the hell is going on.
Any reasonable parent or person would know.
I think
that
we're good
this
now. I don't
is
know.
going to harm.
I guess. I don't know.
And despite that, over and over and over again, Tim Ferriter made that intentional, deliberate decision to treat his son like this. That's actual malice. That's intentional torture. That is willful caging. It's aggravated child abuse. It's child neglect, and it's certainly false imprisonment. It's not just one thing or one moment. It is all the things over and over and over again. What the defendant did was a crime, and that's why we're here today. Like Ronan told you, it was dehumanizing, and it was traumatic, and it should never have been done. Based on all of the evidence, that is why we are asking you all of that evidence, those hours of tedious videos. And I know it was tedious to watch them, but the reason that we did is to see just a moment of what that tedious was like for Ronan here. Based on all of the evidence and based on the laws of the state of Florida, we're asking you for the only verdict that is supported by the evidence and supported by the law. And that is a verdict of guilty. Thank you.
All right, we're going to take a short 10-minute break before we proceed with the defense closing.
Well, the first thing that happened, Beck, was that my computer just decided to go ahead and do an update. It kept kicking me out of the studio, and I didn't know what happened. And then it started doing the update. And then all of a sudden, I came back on, and I kept getting kicked out still. So I just shut everything down, restarted but my router shows I have a good connection. Jack's tired. Maybe he did it. No, he didn't. He didn't touch it. Oh my gosh. That was making me crazy. I hope it's good now. I don't know what the heck. I don't know what to do. I know, me too. Me too. Dang it. That frustrated me. Like, what the hell do I do? Who the hell? Who the hell? Who the hell? I'm over here shutting everything off. Like, what the piss? So I don't know. Do you guys want to back that up and look at some of it? Play it again? I don't know what to do. What did it say? Okay, I don't know what's going on. You missed a bunch. Okay, good, good. I was hoping you guys would say that. Because I think it was good.
There are 3 elements that the state has to prove beyond a reasonable doubt. Elements 2 and 3 are not really in dispute in this case.
Okay, I think we got past that part.
Was under the actually corporal physical punishment, which is not the case here. Here we have intentional caging of a child, which is not corporal punishment under these circumstances.
We're at, guys.
Now,
okay.
Instruction about lesser included crimes, and so the law is that
tell me
there
where
are crimes and then there's a lesser included crime under it. And when evaluating a lesser included crime, you start at the top. And you make
Jerry, that's too funny.
First, did we prove the top crime? In that case, it would be aggravated child abuse.
They are. This is what I want to hear.
Okay,
hey, psycho banana.
You don't need to go and look at the lesser included offenses. The same is true for child neglect and the lesser included crime is culpable negligence. I want to talk about kind of what the lesser is really quickly on each one. The lesser included crime is child neglect, is culpable negligence. For that, you just have to find that the defendant exposed our to personal injury, and he did so through culpable negligence. The reason why this isn't really appropriate is it's subsumed in child neglect. And this doesn't take into consideration the fact that there's a parent-child relationship here, and that the person that the action is toward is a child. This could be any adult action towards another adult. Now, as for child abuse, which is the lesser of aggravated child abuse, there has to be an intentional infliction of mental injury or that the person committed an intentional act that could reasonably be expected to result in mental injury. So again, when we're talking about intent, how does the state prove intent? You don't have to prove, or we don't have to prove the thoughts in someone's head. That would be impossible. But we have to prove that there was an intentional act. So this defendant made actions with intention, meaning it's not an accident. He didn't accidentally build the room in his garage. He didn't accidentally lock his child in day after day. He didn't accidentally make it so he didn't have a bathroom. That's what the types of intent mean under the law. Don't make me do it.
Well, only when you move away from the mic.
The whole time.
That's why I said give her the mic.
So, and that is what the instruction of child abuse means. So, what you have heard from the judge and what is clear is what is not an element of a crime. What is not something that we have to prove in order for you to find the defendant guilty. We do not have to prove that every minute of the day the defendant abused his son. We do not have to prove that he was subjected to that abuse at every second of the day. It can be still child abuse when there are times where you are kind and treat your child appropriately, and then other times abuse the child, which is what is happening here. We do not have to prove to you that his confinement was 24/7. There's been a lot of discussion about, well, there were times where he was let out. Absolutely. The state agrees. Ronan agrees. His sister Fiona agrees. That has always been what they have said, what they have discussed about what happened to him. It's not every moment of the day. There are lots of times where they look like an ordinary family. It's what happens behind the closed doors, which is why we're here. We do not also have to prove that the victim was starving, that he was malnourished. That has never been our contention or the state's claim. We agree that he was not clinically malnourished. The issue with the food is that they systematically controlled and regulated him to an extent where it became abusive. There was social isolation. There was lack of access. There was lack of autonomy to a level in which it was objectively harmful to any person, but specifically to Ronan. That's why the food matters. Yes, he got dinner. He got breakfast most days. You can see on the video, there's 1 or 2 days that as a punishment, he does not get dinner. But we sat here and watched him over and over and over again, eating his meals alone in his room. It also is not a legal defense that a child has some type of diagnosis, a mental health issue, a substance abuse issue, a behavioral problem. You know, whether or not a child is born with a mental health issue or an intellectual disability or a behavioral problem, or an adopted child has those things because of trauma, because of genetics, because of a roll of the dice, that could happen in any case, adopted or biological. That is not a reason or a justification to abuse a child. And that's what the law is. And that's why you're not going to see that in an instruction that it matters at all. It is also not a legal defense that a child has behavioral problems. It's not a legal defense that it was hard, it was difficult, it wasn't as easy as other children. It's not a legal defense that we tried other things. There's no justification legal for what happened here. It's also not a legal defense that we did not get good advice. Now, you're going to get the form in the form of the verdict. There's actually 3 counts, but I just showed 2 here. And I want to make clear that you make a determination, you just check one of these, but your determination on one charge can be different. So that means that you can find him guilty of one charge and not guilty for another. The evidence applies to all of the charges, but your determination doesn't have to matter. And some people get worried that it's going to be like on TV and the foreperson is going to have to read it out. That's not how it works in here. The clerk will read it. And this is the kind of the instruction that tells you that law that I just talked about, that a finding of guilty or not affect your verdict as to the other. Now, there is one instruction here that we haven't talked about a lot at all, and it's called the principal instruction. And you probably noticed that we have presented evidence of both actions and statements made by Timothy Ferriter, and also actions and statements that were done by Tracy Ferriter. And that's because although they're being tried separately, they're both charged. And so that means in cases like that, if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person did. So they're co-defendants and can be jointly responsible for that action. So you don't have to, in your deliberations, make a separation. What? They are acting together in this criminal acts. Now let's talk specifically about the evidence that has been presented. First, you had the testimony of RF or Ronan. And he testified, and one of the first things that he told you and that I asked him about is how he felt about the treatment by his parents. And he told you that he found that treatment to be dehumanizing. He did not want to live in that structure in the garage, and that the defendant forced him against his will. I asked him, well, what would have happened if you refused to go in the room? And he told you that he would have been physically forced to enter that room. He would have been dragged against his will. He also told you that although he did not spend all time in that room, he did spend large portions of his day confined in that room. He told you that every single night he would be locked into the room without access to a bathroom, that there were large portions of the day where he would be locked in. Occasionally, a time or two, he would return from school, be put in, and be not let out until the next day. He would eat many of the meals alone in the room, and there was periods, more than once, where he was in the dark during the day. And, you know, on cross-examination, Ronan also told you that, yes, it's true, he can remember good times. because their abuse of him wasn't absolute, but what their actions taught him. They taught him that his needs, personal, social, physical, did not matter. They taught him, they reinforced that he was bad and that the cruel and inhumane treatment is what he deserved. They taught him that it was his fault, that he deserved this treatment. And we can still see the impact of those lessons on Ronan today. It was apparent when he tested those treatment did to him are still there. We see that those cruel, inhumane, systemically bad, harmful treatment, despite that, those people, defendant, are still the only parents that I've ever known that still want to please them.
Action, facts, non-evidence, and proper argument.
Overruled.
For a child, and you heard it from both Dr. Myers and Dr. Rappa, for a child, this type of behavior can be normalized. It's complex. It's confusing to have the people, the only people in the world that you are supposed to love and trust, to systemically treat you this way. And so for him, for Ronan today, as a 16-year-old, still a child, he needs to call it a mistake and say that they should be forgiven. But that's not what the law is. The law, when we look, Karen, sorry, did it again. When we look, we see that this was a systemic, harmful, cruel action by those people that he loved and he trusted. And under the law, it's something that's called child abuse. Now, in evaluating the testimony, we also have the testimony of Ronan's older sister, Fiona, who is now 17 years old. And so when this was happening, she's about 15, 16 years old for the time in Florida. And in that white box is one of the instructions you got, and it's about evaluating the credibility of witnesses. And in evaluating the credibility, one of the things that we look at is, does the witness's testimony agree with the other testimony and other evidence in the case?
Ms. Coakley, carry the mic.
I never wanted to be like a pop star, and that's how this makes me feel. Does the witness's testimony agree with the other testimony and evidence in the case? Fiona confirms, yes, he was locked in the garage. She confirms the status of the room. She says that he had no other room in the house. She also says that the defendant is confined to that room for large portions of time in Florida, and that he is punished differently than his sister for the same action. She tells us that she was allowed to go to the bathroom. She had a room. She had access. And so did her sister Nola and even the baby Pierce. She tells us that at no point did she ever feel that there was any need for her to be protected from her brother, that she was never here for him, and that he never physically harmed her. There's one incident she can tell us about where he stole from her in Arizona. The defendant's actions towards the victim were normalized in the family. And I know it's hard to hear because we did her through closed circuit, but as the judge told you, if it would help in your deliberations, you can re-listen to her testimony, and you can listen to the audio, not from this courtroom, but from the courtroom we were actually in. But there, at the end, on that second day, we talked about, did it just, because this treatment was happening so often, did it become normal? And she said it was. And she said that at the time, I didn't have a name for what was happening to him, but I do now. And it was abuse. And then we have the testimony of Dr. Myers, who's an expert witness, a child psychiatrist who still actively treats patients at Brown University. And he told us that based on his review, that the actions that there was no legit justification for this ever, and the only reason this is to harm someone. He told us treatment of Ronan resulted in isolate, depressed, lead to
Not know. My internet says it's good. I do not know what the hell is happening.
I'm on the same boat as I don't know. You want to just put on my data and that?
Look, I went on camera like this.
Hmm?
I went on camera like this without, I just put it on.
I still didn't hear what you said. I run a camera like this. That's what you said.
and so his son is in an 8x8 box. The area that you're sitting in is bigger than that. Oh,
Sustain.
you can use your common sense for how big 8 feet is. Alone. And remember, we're looking through a camera that is has some night vision capabilities. Ronan told us what it's like to be in there, that when the lights are off, there is no ambient light. There is no window, that he's sitting in the pitch dark. So let's talk about the application of the evidence to the law. Aggravated child abuse. Malicious means wrongfully, intentionally, and without legal justification. In establishing or evaluating what is reasonable punishment, is it corporal punishment? Things that are generally accepted as being a corporal punishment: a strike on the hand, hitting a child on the back of their behind, in a direct response to punishment, reasonable corporal punishment. Reasonable punishment does not subject a child to a risk of harm, and it does cause actual harm in the case here. It is dehumanizing and cruel. It is proportional and limited in duration. So let's talk about the duration. Continuous, it's ongoing, and I think that's an important delineation here, right? This is not a proportional reaction to a behavior like a discipline or a punishment. He has no room in the house. There is no other place for him. Every other space is taken up. The parents have a room. Each adult have a room. Here, so situation where he conforms his standards the defendant wants, and then he is out of the structure of the garage. This is his life, continuous, even in the best case scenario. But we know that it was more insidious than that, because we look at the duration. January 6th, he goes in at 8:10 p.m. That's when they lock up the door for the final time. No more bathroom, no more glasses of water, certainly no snacks. The door's not open until 7:10 in the morning. He's in there for 11 hours overnight. January 8th, he goes in at 9:39 p.m. January 9th, the door is not open again until 8:35 in the morning, 11 hours. January 9th, 8:36 to 7:39. January 10th, 8:36 p.m. until 8:25 a.m., 12 hours. No bathroom, not a drink, not a chance of getting a snack. No way to escape if there is an emergency or a fire. Locked, deadbolted inside. When we look at January 13th, 4:49 p.m. to 6:18 in the morning, 13 hours on a regular basis. And the exhibit that the state showed you, all of the ring videos are in from that entire time period, but then we showed you hours of videos that showed every event. So him going in, and then when they come in again, he gets out. So those are the major blocks, the major events. When they come in, they go in, they out. And those are the numbers that we're talking about. When we look at the total in a day, okay, fine, not just overnight. How much of a 24-hour day is he in the room? On January 10th, he goes to the bathroom between 7:39 and 7:45 a.m. or 7:43, so that's when he's let out. He leaves the room at 9:05. He told us he got left around 9 to go to school. And then he returns to the room at 4:59, so after school. And then he leaves the room to go to the bathroom at 5:56 to 6:18 p.m., and then he's in for the rest of the night. So the total, if we go 12 a.m. to 12 p.m., is 14 hours and 22 minutes of a 24-hour day, and he went to school. Huge portions of this child's life are alone in this room. On January 13th, same thing. He goes out for 2 minutes to go to the bathroom at 7 o'clock in the morning, almost 8. He leaves the room to go to school at 9 o'clock. Back in the room at 4:49. He gets dinner at 7:02 and lights off at 7:26. He's in there for 16 hours. If we're going from 12 a.m. to 12 p.m. And he went to school. January 20th, same thing. 6:43 to 6:45. Leaves the room at 9. Back in at 4:45. This time without the lights on. Dinner at 7 p.m. Now, was this every single day? No, because as we look at January 23rd, he gets unlocked. He gets released from the cell his father made for him at 9:07 a.m. and he's not back until 7:10 a.m. So yeah, he's out for most of the day this one day. That doesn't change this though, the psychological impact. And when we look at the proportionality, it's important to remember that the time frame that we are talking about is the crimes that occurred in Florida. And so that is from December 2021 until January of 2022. You can see the things that he is getting in trouble for on that video. He's getting in trouble for stealing candy on that very first night. You stole chocolate from us, his mom says. Having an iPod in his room. Having a bad attitude. Lying. He tells a story about having a mock trial, and that wasn't true. Dr. Myers told us that kids subjected to this type of condition can have a fantasy life because they have nothing else going on. And so they have to have like a myth of themselves. Those are the things in Florida that he is being subjected to this type of treatment for. And I want to talk a little bit about intent, because there was a lot of discussion from the defense about intent. How do we determine someone's intent? For aggravated child, it has to be that they maliciously caged. Those are intentional actions. You have to prove that actions that they took were intentional, that he intentionally, purposely put him in that structure.
Objection, misstatement of the law.
Overruled.
That it wasn't an accident. That's the intention. That he willfully tortured, that he maliciously punished. Not every idea that was in his head. How do we determine as a jury? Look at this. You can make reasonable inferences from that to his. Look at the defendant's actions. That he did not give the victim room in the house. He hired a contractor specifically to do this. He said, no, controlled from the outside, up, and a deadbolt from the outside. No bathroom. And he put that bucket in there. Each one of those steps are intentional, specific, deliberate acts. It's not an accident that this happened like this. We know exactly what he intended to do to his son. He set up the room. He put the camera in there. And then he forced the child to the screenshot from January 9th, where he has to use the bucket. He had been in the room since 9:12 p.m. the night before. And this happened again and again. And in the morning, in one of the videos, you can hear the defendant tell him to take out the bucket and say, your neighbors don't need to see your piss bucket. From the outside, everything looked okay. But what was happening inside that room? Abuse. We see the defendant's repeated actions to socially and physically isolate the child over and over and over again for hours last week. We watched Ronan alone in his room eating. And Dr. Myers told you about the impact of that type of social isolation. His actions to take away every little step and bit of autonomy that he had no control, the temperature in the room.
Okay. Did you turn the air on in your room?
Are you supposed to touch that?
Did you hear Baba?
Yes.
Did you hear his question?
No.
Are you supposed to touch air conditioning?
No.
Why did you touch it?
It was getting hot.
I don't give a shit if it's getting hot. You're a tough guy. You don't touch the air conditioning. I'll deal with you tomorrow on that.
You know, in opening statement, defense counsel said that there was just a design flaw in the room. Not a flaw. They're intentional choices. This is what he wanted to happen. This is what the environment that he intentionally subjected his son to. And that no reasonable person would think was appropriate or acceptable. And then after they have that conversation, both parents come in and ransack the room again and leave him with even less stuff sitting in the room. We have the defendant's actions, his choice that not only would he substantially socially and physically isolate his son, but that they had to subject him to hours of sitting in the dark.
Is it a bad attitude? Yeah. Oh, so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here?
What we have here is anger and derision. We have spite, and we want to cause him harm. That's why you're not trying to address behavior. What you're trying to do is maliciously punish him and make him sit in a dark cell for hours during the day. When we look at This is a few minutes later.
So good, man, attitude? Yeah. Oh, you're so tough. You say that, you're gonna hold it out? Better dude. Okay. Okay, what's this here? Bad attitude? Yeah. All right.
So when we're talking about like the reasonableness of the punishment, like look what he's doing that for there. He has a bad attitude. His 14-year-old son has a bad attitude, and that's why he gets to be locked in a room with no lights, which Dr. Myers told us is the same as solitary confinement, something that is universally condemned for most humans, but certainly for children, because of the psychological harm that that type of treatment causes. And we can see about how often that type of thing is happening. The camera is installed in the room on January 5th. That's the very first video we watched. And we went through each of these. We see that on January 9th at 8:36 p.m. They're mad at him. He's in the dark. No ambient light. A 4x4 room. On January 10th at 6:18 to 7:06. Again, dark. On January 11th, 4:45 to 8 o'clock at night. And he doesn't get dinner that night because they're mad.
Ms. Coakley, pull the mic up because it's a recording issue for
Because
me.
they're mad. No dinner. On January 13th, again, 4:49 to 7:02, 2.5 hours in the dark in the middle of the day. And then they come in, and at 7:55 again for the rest of the night, pitch dark, no ambient light, not a window, 8x8. On January 14th, again, 4:49 to 7:02, he is sitting alone in the dark. Like Dr. Myers said, systemic, ongoing psychological torture of a child. January 15th, 5:04 to 7:32, 2.5 hours more in the dark. On January 19th, 7:45 p.m., those lights get switched off again. On January 20th, 4:45 to 5:51. January 24th at 7:08 p.m., he's in the dark. And then January 28th is the last day. It's the day that he runs away. The defendant made deliberate, intentional actions. He put his child, a child that he knew was vulnerable because of his early childhood experiences, into this circumstance. Every single night, for periods of time during the day, he locked the door over and over and over again and didn't allow him to even control the temperature. His only option was to use the bathroom in a bucket, and he had no access to water on multiple occasions. And then in evaluating his intent about what he is trying to do in this circumstances, we have what he says.
Tell me something? Stand up. Tell me something? Don't tell me what. This is your one chance. Don't look at me like an asshole. You want to tell me something or not?
I have a nightmare.
Yeah, from where?
Blue van.
Where?
Green van.
Excuse me?
Green van.
Stealing again? I mean,
What
really?
the fuck is wrong with you?
You're stealing,
so fucking
like,
disappointing.
chocolate, and then you got so much stuff in your
You're
room.
fucking great. You're just such a disappointment. You're gonna lose. I'm gonna take you out of that school, and you're gonna be in this room.
He's gonna be.
You're this close.
Where are these in here? Where are these?
Where are they?
These, this is like belongs to the kids, or
Well, let's get very soon. See what your lion does? See what your lion does? You see it?
is this
We're going back to this?
is this tape here?
So what we have is anger and derision. That's what's governing his decisions. And that's why we know that it's an intentional act.
Stand up. Why are you giving people a shit attitude? Fuck that. Don't say I don't know. Why are you giving a shit attitude?
I'm not thinking.
Fuck that! Why are you giving a shit attitude? Answer me! Before I get really fucking pissed off, answer me. Why are you giving her a shit attitude? We're in school today talking to your people to give you a better opportunity. And you got a fucking shit attitude?
And after this, when he exits the room, he again turns off the light and leaves him locked in the room. And so how does that impact our ability to determine or make a conclusion about what his intent is? This isn't about getting a productive response or even having a proportional type of conversation. This exchange is about him having a bad attitude. And you can see even here, Ronan tries to say, I'm not thinking. That's why I'm having a bad attitude. And there is anger, aggression, physical, the specter of physical force, as opposed to having any kind of conversation with the child. And then the response is to not have a conversation with them, not try to do anything that would be useful. Instead, locks him in the dark in an empty cell and puts him, turns the lights off. Because he's mad. He has malice towards the child. Now, I want to talk for a second about Arizona, because I know that maybe it can be a little bit confusing. We've had a lot of conversation about things that happened in Arizona and what happened in Florida. The defendant is charged with the conduct that occurred in Florida. And the judge has given you an instruction about how to weigh that conduct and how that can impact your deliberations. And that instruction is that the evidence of those other crimes, wrongs, or acts can be considered for the purpose of proving motive, opportunity, intent, preparation, plan, knowledge, identity, or the absence or mistake of accident. So that means that when considering the defendant's intent here, you can take into consideration his actions in Florida. You can take into consideration that this is not just something that he suddenly came to in Florida, that it just happened for 30 days. You can take into consideration that this is something that the defendant had been subjecting his son to for a period of 3 years. With, as Dr. Rapper told you, really no improvement, right? Like he was still having the issues that the defendant was concerned about, the bad attitude, stealing the sprinkles. And so, despite the fact that it was not helpful, that it was harmful, he continued to do it. It's an intentional act, that he continued to lock his structure, that it's his child in that structure, that there was a bucket, that there was no control over the lights or temperatures, that he used physical and social isolation. That this is not just something, oh, let me give it a try. This is something that he had been subjecting his child to for years. And you can take that into consideration when determining his intent here, that this was his plan, that he wanted to do this, that it was not a mistake. You can also take into consideration the physical abuse that happened in Arizona and evaluating the evidence in this case about what he was doing and what he was intending to do. He told you that there were instances where she could hear the victim screaming while he's being struck in the garage in Arizona. She told you that there was one incident where he grabbed the child by the neck and lifted his feet off the ground, and Fiona was worried that he might accidentally kill her brother. And Ronan told you about those incidents too. And the reason, although he's not charged for those incidents here, the reason they matter here in your evaluation of the evidence is because that threat of violence, the fact that the defendant's anger and aggression and grabbing him by the neck like he does in the video, of shuffling his arm, of getting up in his face, is not posturing. That threat of violence is very real and significant for Ronan. And you can see that in the videos. You can see him cower. You can see him stand almost withdrawn. But it influences what the defendant is trying to impose on him with those threats, and also Ronan's understanding of what can happen if he disobeys. So let's talk for a second about the defense case. They put on some witnesses, and for the most part, the first day witnesses were the defendant's friends, with the exception of the teacher. Those friends do not know and never were in Florida. They do not know what was happening when the defendant was alone in a home with his son, and they do not know the type of punishment that he was subjected to. And absolutely none of them have any firsthand knowledge of what happened in Florida, because they never came in Florida, they never saw anything, and they do not know. The defense also put on a number of videos that we spent the better part of yesterday afternoon watching, which are times where Ronan was outside the house. And what we see from those videos that we saw yesterday is that for the vast majority of the time in the recording, that the victim is able to conduct himself in a family environment. He plays nicely with his little brother Pierce, who seems to very much love him and want to play with him and is following him around and trying to get him to interact. He is able to behave appropriately with his other siblings. You see him playing with the dog. We do not see violence or aggression. You know, there's been kind of this idea floated that we had to keep the family safe. There is no evidence of that. The evidence is to the contrary. The person that was jeopardizing the safety of the Ferriter family was Tim Ferriter. We see that there are periods that he wasn't confined. And we agree with that. Ronan told you about that. When we look at the videos, we showed you on a scooter, which is on January 7th, 2022, after school. You can see in the videos that the state published, that's the outfit that he puts on, leaves for school, comes back, he plays on the scooter. And then at 5:42, he's off the house. He's in there until he goes to sleep in the room where he cannot leave to get a glass of water or to get a bathroom. On January 9th, this is a Sunday, 8:45 a.m., the state's evidence. Then, like he told you, he was often, when he was outside of the room, and the defendant who the defendant for sitting at the table while the child's working. And then later that same day, there's those videos. Like he told you, one of the things that he had to do was to clean up all the rocks. The state put into evidence video after video of him out there by himself, by hand, taking up the shelves. You see the defendant come take a look and come back and say every single rock. So yes, he did get out of the house, and sometimes he got to go on a scooter. Sometimes he had to do yard work, but at 6:25 every single night or earlier, he's locked in that room. The fact that on one day he watched a football game with his dad does not vitiate all the other days of systemic abuse. And then we have the testimony of Dr. Rappa. Dr. Rappa is their expert, a psychologist, and she told you that the way they chose to manage was probably the worst way that any person could manage these types of behaviors. She told you that the defendant's actions are the complete opposite of what anyone should have done with a child that has one of these conditions. She told you that there is a likelihood of psychological harm, even children that had no underlying behavioral issues, that this is going to be harmful to anyone, but especially someone like Ronan. She talked about PTSD and reactive attachment disorder, and she told you that the defendant's actions would exacerbate the symptoms, that what he did made it worse. Actual harm. That is the defendant's own evidence. She says that this is not the recommendation that they received from any treatment provider, that she went through the records and that what was recommended was medicine and therapy. And that there was very little of that done. And the last time that they dealt with any mental health professional for their son, who, according to the defense, they're so concerned about his behavior, was in 2019. The time frame that we are talking about is December of 2021 to January of 2022, 2 years later. No efforts. And we can see, and it's in evidence, you can take a look, when he is enrolled in school at the Palm Beach County School District in this middle school in January of 2022, you fill out enrollment paperwork. And there, Tracy Ferriter says, normal dental, normal skin, normal eyes. Any other specific illnesses or social or emotional behavior problems? No. At no point did they try to get an IEP, an individual educational plan. At no point after that.
Objection, facts not in evidence as to the IEP.
Overruled.
We heard that, there was one email sent to someone about transcendental meditation, 2022. You know what else happened in 2019? Instead of doing anything productive to deal with the trauma maybe experienced by their sons or their behavioral issues, they locked him in the garage. Their biological son, Pierce, was born. They needed the bedroom. Ronan went into the garage. 2019 is when they stopped with the mental health professional. Those actions, taking reasonable punishment to correct something. It is malice, it is willful torture, it is intentional caging of a child. Now, Dr. Rappo, there was a discussion about what started the PTSD. Was it the defendant's abusive actions, or was it just his childhood neglect? And you got an instruction about how you can evaluate a witness's testimony. That instruction is that you get to use your common sense in deciding what is the best evidence. You get to decide what should be relied upon and consider your verdict. You may find some of the evidence reliable and some not. You can say, well, that makes sense and I think is appropriate in light of the totality of circumstances. And some of it doesn't really matter. But I agree unequivocally, the defendant's actions were harmful. They should never have occurred. They led to worse behavior for the victim. That there was absolutely no benefit to what they did. And they were harmful. In a criminal case, the state's burden is proof beyond a reasonable doubt. And the law instructs us on what a reasonable doubt is. A reasonable doubt is when you're possible doubt, a speculative or imaginary doubt. Such a doubt must not influence you to return a verdict not guilty. So what does that mean? If you're back there in the jury room and you find yourself speculating, well, this is what they could have meant. It's not based on today in courtrooms around the country need to be ordinary people. And we ask them to use their common sense about what is reasonable and about what is appropriate and what evidence is proof beyond a reasonable doubt. For about 6 weeks, Ronan Ferriter was locked in a room in Jupiter, Florida. And yeah, he got to go to school, and sometimes he got to go on a scooter, and sometimes he got to play with the dog. But as you heard from Dr. Meyer, that doesn't change the impact of this type of treatment has on any child, but absolutely on a child like Ronan. The defendant's intentional, repeated acts caused harm. Any person would know, any reasonable parent would know that this is not acceptable. Any reasonable parent or person would know that this is going to harm. And despite that, over and over and over again, Tim Ferriter made that intentional, deliberate decision to treat his son like this. That's actual malice. That's intentional torture. That is willful caging. It's aggravated child abuse. It's child neglect, and it's certainly false imprisonment. It's not just one thing or one moment. It is all the things over and over and over again. What the defendant did was a crime, and that's why we're here today. Like Ronan told you, it was dehumanizing, and it was traumatic, and it should never have been done. Based on all of the evidence, that is why we are asking you. All of that evidence, those hours of tedious videos, and I know it was tedious to watch them, but the reason that we did is to see just a moment of what that tedious life was like for Ronan here. Based on all of the evidence and based on the laws of the state of Florida, we're asking you for the only verdict that is supported by the evidence and supported by the law. And that is a verdict of guilty. Thank you.
All right, we're going to take a short 10-minute break before we proceed with the defense closing. All right, everyone may be seated. Court will be in recess until 3:10.
Okay, I'm sorry, I'll fix it right now. We can go ahead. Up.
All right, everyone may be seated. Ms. Murad, is the defense ready to make its closing? Yes. All right, you may proceed.
Sorry, I went outside to do something, of course. Immediately went to recess.
There is not one moment that I want you to think that this defense is about whether or not Ronan deserved the treatment that he got, because it is not. Or that the fact that he is vulnerable or had medical issues from early childhood is justification. But it happened, because it is not. However, we are in a criminal courtroom. And what you have to determine is whether an act, a horrible act of parenting, a bad act of parenting, bad choices amount to a crime. And in this case, they do not. I told you at the beginning of this trial that Tim Ferriter had to make tough choices based on the experience that he had had with his son, Ronan. And I'll talk about that more in detail. But what I want to start with is sort of the bedrock of any criminal case, which is an understanding of what reasonable doubt is. There is an instruction that you will receive, and we'll talk about that later on in my closing argument,
Approach. All right, objections overruled. You may proceed. And that's without prejudice to the state to address it in rebuttal.
So there's different ways to understand reasonable doubt. And I think that a helpful way to understand it is in terms of sort of the other standards that we have. So at the bottom here, you see reasonable suspicion. And that is like a super low standard. That's why it's on the bottom. So that is the standard that a police officer has to have just to sort of stop you on the street.
Sustained.
When we talk about reasonable doubt, it is in reference, right, to all the other standards, because beyond a reasonable doubt is the highest burden in our justice system. Normally, when we talk about a criminal case, it's different than, for example, a civil case where you are deciding whether or not something is done by the preponderance of the evidence. That's about 51%. The next level up from that is clear and convincing evidence. And that's the standard required for the government to take your children away.
All right, I'm going to instruct the jury that the court will provide and has provided you with the instruction on what reasonable doubt is. Attorneys can comment on the law that the court has provided, but anything else other than what the court has provided on the law, the attorneys cannot address, and you're to disregard that. So with that instruction, Ms. Murad, you may continue.
Thank you, Your Honor. Clear and convincing evidence is the standard by which government
Overruled.
can take your children away from you. And then higher than that, you have beyond a reasonable doubt, which is the highest burden in our justice system. And this distinction is important because when we talk about bad parenting or someone that shouldn't have their kids, there's a standard for that in the legal system. There's a system in place for that. What you are being asked to do is determine if something is a crime, if it rises to the level of reasonable doubt, such that a person whose liberty and freedom is at stake, as it is in any criminal case, should be found guilty of a crime. You are not being asked whether you condone of Tim Ferriter's actions. I put up an expert, Sheila Rappa, who says she does not condone of Tim Ferriter's actions. And I didn't do that not knowing what she was going to say. This case is about a different sort of location and time than what the state's talking about. There is no dispute that what Tim Ferriter did caused harm to Ronan Ferriter. My own expert got up and told you that. The question before you is whether or not that was done with the appropriate intent, whether or not those elements that the state mentioned are met. And so I want to talk about those in specific. Let's start with this. What are we actually on trial here for? The state mentioned a instruction towards the end of their closing argument regarding the things that happen in Arizona. And of course, the defense brought some of that in. It offers context. But the decision that you are making is whether or not Tim Ferriter committed a crime during about the 6-week period that he lived in Jupiter, Florida, between January 5th to January 28th. That's when the video goes up in the room. They move in a little bit before Christmas. That is what you are being asked to do. If you believe that Tim Ferriter committed a crime in Arizona based on the testimony, but you do not believe that the state has proven beyond a reasonable doubt that he did so in Florida, you must find him not guilty. I don't normally do this, but this is a lengthy closing, so I want to make sure that we talk about all the different sort of reasons why Tim is not guilty. I'm going to talk about these all in turn. They apply to different instructions. So rather than taking you through instruction to instruction, I want to focus on the reason for it being not guilty and the instruction that it applies to. So we'll go through these one by one. I first want to start by talking about sort of two ways that you can find him not guilty that are pretty related. First, he did not have criminal intent. This applies to every charge, right? Because criminal intent is something that is unique to a crime, as opposed to something something along those lines. Even if you find that the state has proven every element, including the criminal intent element, as to child abuse and aggravated child abuse, you can still find him not guilty because of the parental affirmative defense. Now, the way that it reads is it is not a crime for a parent of a child to impose physical under circumstances physical injury. This is the important part. Parent, that's not an issue. But the state proved beyond that is not reasonable under circumstances to find him guilty if the charge has been proven beyond a reasonable doubt. This is a little hard to understand. First, the state has to prove every element of the aggravated child abuse beyond a reasonable doubt. And then the second that's not stopping, that becomes explosive. Ronan has when Ronan feels angry or has sort of a strong emotional reaction, he's not able to control that in the way another person might. he also has a lack of inhibition. And that's why when he has consequences, that's not something that he's entirely understanding. She said that it's very hard for someone who tested like Ronan did to be in control of themselves, and they have a lack of insight into their own behaviors. She also explained that this testing, right, goes back to early childhood, and that's not really in dispute. The state's own expert, Dr. Wade Meyer, said that he believes Ronan has probably an attachment type of disorder from the time that he lived in an orphanage. Again, there's no dispute that the Ferriter's actions exacerbated that, right? Dr. Rappa told us that. That's something that the defense is completely conceding. But both Wade Myers and Dr. Rappa say that this is something the Ferriters did not cause. It is from very early childhood. And what the key is, and Dr. Rappa talked about this, to it, their behaviors before 2018, right? That's when we're talking about the timeline. We know that Pierce was born on February 8th of 2019. But Ronan's testimony, a room was built in the garage in Arizona. Before that, while Tracy was pregnant with Pierce, a latch was put on his door in Arizona. So that has to be 2018, early 2019. To that time, Dr. Rappa testified about records that she reviewed from 2015, elementary school emails about ongoing and persistent behavior. And I asked her, because look, I understand in the statement, a lot of it, stealing sprinkles or activities that are just considered childhood behaviors. It's very hard to distinguish what constitutes regular behavior, what constitutes a disorder. Asked Dr. Rappa that during her direct examination. And what she said is that it is the persistence of these behaviors, that despite there being consequences, by being boundaries, they continue and continue and continue. In behavior, right? He admitted to harming other people. He admitted to offering his brother years experiment. Said Borzati testified that the time that there were vinegar being spilled and was found with knives in his backpack. And the cross-examination on that was, well, do you threaten you with a knife? Do you use a knife? An 11-year-old shouldn't have knives in their backpack, right? That's everyone's common sense. As a young child, there are things you cannot have the courage to come up with this entire story. That is something that gets to the level of being manipulative. And those are the concerns that were happening with Ronan throughout his life. And that's corroborated per Dr. Rappa prior to 2018. Through records that she reviewed, through Ronan's own deposition that she reviewed, through, I think she listed off 25 items or 26 items that she reviewed in coming to her opinion. You rely on trust. We were in a relationship. What we and we when someone do this or I'm not going to do this, you follow through with that. And that relationship with parent and as natural response to control. Right? And we get in our everyday lives. If you have a kid who's out, doing, you don't get paid. If you are someone who is in school, you're going to be a timeout. You see in this case that it is taken to an extreme. It's also in response to an extreme because that kid joyriding who doesn't get their car stops. Most people's children stop when they say you do this and you take away your items. I'm going to put you in a timeout for a reasonable amount of time. I'm going to ask you to stop doing it. I'm going to ask that you not, hurt people in school. I keep getting emails from school about how your violence is becoming a problem. I need you to stop doing that. Eventually, kids stop. But Ronan didn't. It persisted over and over and over again for years. I want to show you a video of how Tim Ferriter responded.
The next step. You don't give a shit. And you want to run away? See how that takes. What's going on in the world, but we don't quite know. Give it time. Because it's not responsible. And when I say I'm not saying so do that. If you want to go your way, if you want to do it, I know this again and again and again. I'm not tired for this shit. I got to deal
if you are hiding knives, pretending to be people that you are not, and stealing money from your friend's parents, and bringing these people to school, things that so often at your elementary school setting, when you are 7, 8, and 10, when you is this idea, we talk about malice and intent, but it's just something that Tim Ferriter enjoyed. The benefit your kids were my toddlers are just hyper vigilant all the time. They have to watch every minute of what a kid does. They're gonna right that's that life. And Ronan said yes, whether that was a timeout, whether that was getting yelled at, whether that was getting in trouble. It was always in response to something. And I'll concede what Dr. Rappa said, that the tone was not appropriate and the strategy was not appropriate. That is not in dispute here. But to say that it wasn't reasonable to Tim Ferriter, who had a reason every time it was happening, that is inaccurate. When he talks about the AC, Ronan admitted in his cross-examination, it was right at the end of my cross-examination, I asked him about when he almost started an electrical fire at the home in Arizona, right? And he talked about how he was playing with the lights and tried to mess with the light switch. And he initially said, it wasn't going to be a fire because I would know how to fix that. And I said, that could really hurt somebody. And he said, yeah. So he's not allowed to touch electrical items or, equipment in his room. You can hear when Tim is talking about specifics. We talked about that. So I want to talk now about what you experienced during this trial versus what the Ferriters experienced over the course of time. So this trial, right, is really talking about not just what Ronan went through, but also a parenting relationship. Anytime something's happening to a kid by a parent, there's a relationship there, right? A parenting relationship that spans time. And what you saw was over about a week and a half. I know it feels like forever, but it was about a week and a half. And when you saw Ronan testify, it was about 2 hours. That is not what you are seeing in those videos that the state played. What you are seeing in the videos the state played is after year 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 of ongoing issues. And you
Sustained.
are
Jury is instructed to disregard the last comments of counsel.
And what you are seeing is a family at their wits' end. There's no doubt about that. And I know a single, take away a child, take away all the variables, a child with behavioral issues or a diagnosis or even behavioral issues. A parent and a 14-year-old or a 13-year-old, a preteen. I don't know a single parent who would want their worst couple months, their worst year with their relationship with their kid filmed on camera for everyone to see without any context, without any understanding of what was going on the years prior, without any understanding of who they are.
Sustained. Jury is instructed to disregard counsel's comment on her belief on the evidence.
We talked about whether or not this was in fact malicious punishment. And both Wade Myers and Dr. Rappa testified about that. And they testified in a different manner. Here's what I want to remind you about Wade Myers. The information that Wade Myers had was curated by the state and provided to him in the same way that we provided information to Dr. Rappa. But what he said is that he received 40 videos of the 21,000 that exist in evidence. He received 40 videos of the 8 hours that you watched of the state's evidence and the 3 hours that you watched of the 14-hour video that the defense put in evidence. That is not an entire picture of what happened in this family. In fact, if I remember correctly, when my colleague on cross-examination videos in this case, Wade Myers' face visibly was like, oh, I didn't know that. So his opinions are based on a limited set of information, acknowledging that he may not have the entire picture of what was going on in this family. Dr. Rappa testified that she didn't believe that this was malicious. And you can evaluate the credibility of any expert the way that you want. Dr. Rappa, compared to Wade Myers, testified on cross-examination in a manner that was very honest and not in any way
Sustained.
And not
It'll be up to the jury to determine credibility.
she didn't fight with the state in the way that Wade Myers did, the way that Wade Myers did with the defense. And she admitted to everything as it relates to the harm caused, the fact that this is an inappropriate way to handle a child. That is something that Dr. Rappa said was absolutely true, right? So when she's looking at all this information, she's telling you that the reason it's not malicious is because this was a poor effort at parenting a child that has issues that these parents did not understand and that providers did not give them. She said that it's common in mental health types of situations for families, parents, to get really, really frustrated because they are, Ronan's on clonidine. That's not working. This isn't working for sleep. They're getting advice about limit setting. That's not working. They're getting advice about take him to therapy sometimes. The one-on-one therapy that he had with family counseling wasn't working. It's not changing the behavior in the school. And that's happening year after year after year. And Dr. Rappa said that it's really common in her field, and she's worked with a lot of children who have similar issues to Ronan and a lot of parents in these types of situations as well. And it's very normal to feel extremely frustrated with the mental health system, right? Because you keep doing stuff, you keep taking them to the appointments, and nothing is helping. And not one of these doctors recommended inpatient treatment. Not one of these doctors recommended what Dr. Rappa said would be appropriate treatments for reactive attachment disorder. So they're following the advice that they are receiving, and nothing is helping. When I was talking to Ronan in cross-examination, he had to be reminded of this, but he said that he was going in Arizona to appointments about once a week. So many that he didn't remember who the providers were. So this idea that they didn't try is not true. Ronan himself has said that he was going and seeing people once a week. Both experts testified that there were emails between the schools and the parents talking about Ronan's behavior, trying to figure out how to deal with it. Miss McCoy, the former teacher, testified that after the incident with Nola in the classroom, Tim came with Ronan separately and Tracy went with Nola in order to try and talk to the teacher and figure out what was going on. The idea that these parents were not involved and not trying is distant from the facts. There were also non-medical efforts, and I know that it sounds silly, the meditation, but this is a family that from when this child was a kid was like, okay, what are the non-medical options that we can try? What can we do to burn off his energy? What if we don't give him sugar? Maybe that'll help. What if we don't, put him in karate, jujitsu, put him in these activities like track, what he did in Arizona. He did chess club. And one of the videos you can hear Tim say, Ronan didn't get it because he stole an iPod or an iTouch, but he said, I was going to get you that gaming computer that you really like because this kid is really good at IT, at gaming, at that kind of stuff. So they're trying to get him into activities that they think will help his behavior because none of the medical interventions were doing it. The state mentioned in their closing argument that after 2019, there was no evidence of any medical treatment. That's not true. When the state was asking Dr. Rappa the same thing, she said, I think there were some appointments with Kenny Miller. And when they started school in Florida right before Christmas of 2021, there's a record that shows that they went to a pediatrician like you're supposed to go to, and that they asked for a referral for a psychiatrist, right? And you can use your common sense here. That's not something that happens overnight in any doctor type of situation. You have to get a referral for psychiatric care. I want to go now to points 3 and 4 that I had in that sort of initial slide or roadmap. So I want to talk about with you Ronan's sort of life at home. And this goes to the elements that this was not torture, which goes to the aggravated child abuse, and that it was not malicious punishment, which also applies to the aggravated child abuse. Where Ronan lived, whether it is appealing or not, is a room. And I want to show you, this is Defense Exhibit 2. When Ronan moved into his room, this is what it looked like. And you can see the girls' rooms. The photos aren't great, but this is not in size that different from what the girls' rooms are. It's an 8x8, which is about the size of a small room. He has his toys, he has his Legos, he has everything on the walls. This is how the room started. The room itself for Ronan was not punishment. It was his room. And if you look at the videos in State's Exhibit, I think it was 16, you can see Ronan doing things in his room that have nothing to do with being in trouble. There's one video where he's FaceTiming a friend and showing them his room to show kind of where he lived. He's playing games. He's playing with Legos. There's a video in there where Pierce comes in and tries to play Legos with him, and he says, no, I want to play alone right now. Ronan also testified that that room was not always locked. It was locked in the evenings when he was asleep, and it was locked if he was in a timeout. The state also mentioned that, you know, this narrative that this was a secret. The Ferriters hired a contractor to build this room. It was not privately done by them. They also had the garage door open for much of the videos that you watched yesterday, where Ronan was coming in and out. And so this is not some sort of secret. The teachers knew. There's emails back and forth about Ronan's behavioral issues. The fact that Ronan had restrictions that other kids did not have or that his siblings did not have was not a secret.
Sustained.
The state's expert characterized, and the state's been characterizing this room as a cell or a box. And I showed you this photo. It's a room with a desk and a bed and toys, and it has stuff on the walls until Ronan took them out or they were taken away from him because he was in trouble. I want to talk to you about the bucket that was placed in the room. Tim says to Ronan in one of the videos that you watched it was one of the videos that the state presented. So it was a couple days ago. It was last week. I don't want you to use it. Call us so that you're not using it. Throughout that 6-week period of time, it is used 2 to 3 times in total. What it is not is deprivation of a bathroom. It is a terrible solution to wanting to make sure that Ronan in the middle of the night cannot get out of his room. Because as you heard Tim Ferriter say in the videos, he is running away. So much so that he needs to place a monitor on him so that he is not running away in the middle of the night, telling people that he's someone he's not, putting himself in danger. You can see in the videos of the sort of timeouts that Ronan's in, and you can always tell because they're always like, do you still have a bad attitude? Or you don't get your Chromebook for this. You can tell in the videos what's going on that day with the family. And they come in to 30 minutes, and you can see those in the videos, and they say, do you still have a bad attitude? There's one video where Tim actually lets Ronan out of the timeout because he says, you know what, I feel, you know, I'm not in trouble anymore. So this is on January 23rd at 7:10 p.m.
Go, Sean. So did you get mad when she checked your pockets?
No.
But don't get ready to that because you earned that. Okay? It's a nail there. It's in the ground there.
Not to lie down. It's not here.
Go ahead. Good.
So throughout the videos, you'll see this happen, that they're checking in on him. They're saying, okay, are you still going to act out if we let you out of the room? And that happens to children all the time when they're in a timeout, that they have to act appropriately. They have to come out without a bad attitude. And it's never because, as the state represented, that it's just a bad attitude. If you go through the videos, you will see that there are exact incidents: stealing a Chromebook, pretending to be somebody you're not, you know, calling out an issue at school that it's about. I want to talk a little bit about the actual time that Ronan spent in his room. It's state's duty to present you with evidence so you can determine what the truth is in any given case. And we talked about in jury selection how the defense can sit there the whole time and not do anything, right? We did not do that, but it's not the burden on the defense. We don't have to cross-examine anybody. We don't have to put on any evidence. We don't have to put on any witnesses. If that had happened, you would have left the long weekend only with the videos that the state presented you, which was 8 hours of only in his room, only in trouble. It was not until the defense put on a case that any context was provided to what was going on in this home in a daily basis. It is their obligation to present the facts or the relevant facts
Sustained.
It's our obligation to present you with.
The objection is sustained. It's not the state's burden to present with all the facts. It's the state's burden to present all the relevant facts, material to the case that's being decided by the jury. You may continue, Ms. Murad.
And what is material in this case is all of the evidence of what was happening on a day-by-day type of basis. And what the state said in their closing is that, yes, of course, there were occasional times when he was out, and that doesn't negate any sort of abuse that happened. In a case like this, the reason that it is essential is because it allows you to understand the context of the relationship between this father and this son. Their expert, using only the 40 videos that they provided, testified that every time Ronan was around Tim Ferriter, you would see him tense up and be in fear. And when he was in trouble, that was in fact the case, like any child. But when he was eating freely in the home, or watching football with his dad, or doing yard work that all the kids were doing when they were putting up the different tiki torches, he wasn't acting like that around his dad. Because that is not a constant state in this family. It is not a constant state for Ronan, and it is not a constant state for Tim Ferriter. There are other things that happen during the day. And we went through the videos and tried to provide, let me see. Sort of a breakdown of the time that Ronan actually spent sleeping in his room and not in his room. And what you can see is that 43% of the time is spent sleeping. There's one time that they come in the middle of the night, you can see it in the videos, and wake him up to look at his room. And that's on a day that there was a stolen eye touch. I'll show you that. And there are 2 to 3 times that he wakes up to use the bathroom. Other than that, he spends the vast majority sleeping at night. The time that he spends in his room, not asleep, changes over time, depending on if he's in trouble, if he's in a timeout, but that's about a quarter of his day. And the rest of it, he spends at school, at home, playing with his friends, doing chess club, and all the other things that kids do. And so I want to go back to this video that the state presented of him being locked out. So the state alleged that Ronan was locked out of his home in Jupiter, and they showed you one video. That is in fact not the case. And so the first video is what the state admitted into evidence from January 22nd at 12:19 p.m. We've admitted as Defense Exhibit 18, and that's available for you. You'll get all the exhibits at the end of the day. The other videos that give context to this one. Because what was actually happening is that Ronan was gardening with his dad from about 9:30 in the morning.
Sustained.
It's in the videos that you can see that are admitted as Defense Exhibit 18. And his father actually brings him water in those videos that are admitted in evidence, and you can see for yourself.
Let me have counsel approach, please. All right, Ms. Murad, you may continue.
I'm now going to play one of the videos that the defense put in. Under Defense Exhibit 18, there's 3 that offer context to what's going on here. And you can see that several minutes later, Ronan enters through the back door. And again, this is why this is important. You have to have the full picture of this parent-child relationship in order to make any determination about what the parent-child relationship is. And it does not justify the actions that Tim Ferriter took. That was those were bad choices that he made, and we are not disputing that they were harmful to Ronan. What it does not prove is all the elements that the state has to prove, particularly as it relates in what we're talking about now to whether or not there's intent, whether or not it was malicious punishment, whether or not it was torture, whether that's what it constituted. The defense admitted a 14-hour video. We did not show you the entire video because you watched many hours of the state's video. However, the entire 14 hours is in evidence. And what we tried to do is provide as much as we could different days and different sort of experiences that Ronan was having. And it's not just relevant to show the context. It's also relevant to show what's actually true about what happened. This idea that Ronan didn't have the ability to eat snacks when he wanted to. One of the videos that we watched, he was watching football and there was a bag of popcorn on the dining room table and he grabs the entire bag and starts to eat it. This is after the state's expert, Wade Myers, who relied on only 40 of the 21,000 videos, said that this child, and that's part of his opinion, right? Why it's solitary confinement, why he believed it was torture, why he believed it was malicious. He is relying on facts that are not the whole truth. And so, of course, if you only watch those videos or the 40 that the state sent him, you're going to think, as you probably did after watching 8 hours of video, that the entire life of this child is in this room. And that is not true. You saw him playing outside. Prior to January 5th, you see him frequently outside. I know it looks like Tim Ferriter only watches football for a living, but it was December 31st and January 1st. And so there were a ton of football games coming on. If you go later, I think we showed you January 5th, 7th, 9th. You can see them walking outside as a family, playing in the cul-de-sac, playing with Pierce, who clearly really loves Ronan. Ronan fixing up a scooter that he had. That is also the life of this child. Fiona testified, and so did Ronan. This is a busy family. I think in every video you saw Tracy running around in the back from place to place, grabbing Pierce. But you have 3 kids that are around 13, 14 years old, all with their own activities, right? Nola has softball, Fiona has band, Ronan at the time had chess club. And so all these people are running around. They are not eating meals at the same time. They are not sitting around their kitchen table, excluding Ronan, who's in his room. And the videos will corroborate that, should you wish to watch 14 hours of video. That is what you will see, that people are running around getting snacks. At one point, we didn't end up watching this in the 3 hours that we presented. Makes cookies for everybody, and Ronan partakes in that. You see him in the earlier videos, I think it was December 29th, coming back with little styrofoam boxes of leftovers. Wayne and the state are alleging that he had no control over his movement, where he went. And yes, at night, he was in the room with a lock on the door so that he could not get out, so that he could not run away or harm himself or do something around the house or get knives like he did before. That's at night. During the day, he went to school. He was with his family. And there were days that he was in trouble, and we're going to talk about that. And he would be in his room as a timeout because he was not allowed to engage with everybody when he's in trouble, when he gets in trouble at school. The videos, again, it's 14 hours, do get tedious. But the reason it's important is that there are extended periods of time every single day that you see Ronan have full control over his movement, what he's eating, where he's going, walking around the house, playing outside, doing yard work sometimes. We talked about that. Everybody else in the family. That is a family. That is the life of a child. There are days when you are doing chores to do, and there are days you have to help your dad yard in the tiki torches. And there are days you are chilling on the couch with your dad, watching football. There are days where you are in trouble, in really big trouble, because you are so frustrated that you're in trouble. Your parents, or you did something that you didn't intend on doing. And it is the life of a parent that sometimes you need help with the random stuff that your wife's making you do around the house. You have your son help you out, that you're running around dropping the kids off, so you don't have time for everybody to sit down and have a meal or have a breakfast that is exactly the same, or have or make everybody a different breakfast every day. You're dealing with the stuff that your kid did at school. You're getting emails back and forth and having to deal with that. Go to the school, drop the other kid off, and go to work, pay your bills. That is the life of a parent. And sometimes you get frustrated with your kids and you do things that you regret. That is the life of a parent. And that is the life of a child. And sometimes kids and their parents are on exactly the same page, and it is a really good day. And sometimes you couldn't be on further off planets and you are mad at each other. And you say things you regret and you do things that you regret, but that does not make you a criminal.
Overruled.
I want to talk a little bit more specifically about the videos that you saw and what happened during the course of this 6 weeks. So a really important day is January 5th. And you can see from the videos that January 5th was the first day of school. And I want to give you context for what happened prior to January 5th. There's a video in which you can hear Tim getting really mad at Ronan and saying, you just got kicked out of basis. You gotta start the school off right. We cannot be in a situation where you are getting kicked out again from school after school. And Ronan admitted on cross-examination that at basis, he did in fact jailbreak a school laptop, right? That does not belong to him or his parents, and did violent searches on it that were very concerning to his parents, and that they responded to that because as a 14-year-old child, you should not be doing searches like that. And on January 5th in the evening, Ronan is asked, did he do a search after he jailbroke a tablet? And was there something concerning to mom and dad? So we talked about this. Now, when we get to January 5th, the state presented some of this video. I would like to present all of it. And the state represented that the reason Ronan was in trouble on January 5th was for something as minor as stealing candy. That is not true, and that is not what the videos and the state's own evidence show. So I'm going to go through these one by one. I also want to point out that at this time on January 5th, they moved probably, week 2 before, based on the records. He still has everything in his room. He has his toys, he has his bed, he has his computer, he has all the posters that he likes. This is a time before he got in trouble, and it's a real turning point in this 6-week period.
You gonna play a little bit, or you're tired?
Yeah, we'll play a little bit.
So you can see there that there is something going on in this corner that Ronan is doing. And you'll see more context as we go through that he had something he was not supposed to have. And he was hiding it right where he wouldn't be able to check.
You gonna play a little bit, or you're tired?
Yeah, we'll play a little bit.
Now you'll see Ronan rearranging the entire desk and bed arrangement.
I don't know, you have to see.
So at this point, he's moved his desk, right? And we saw in the other videos that they want the Chromebook. It was specifically, you can see Tim when he puts it up on the 5th, that they want the Chromebook to point towards the table. You can see him almost adjust it in that video. And I understand why in any other circumstance that may seem like very unreasonable supervision for a child. A kid should be able to use their devices how they want. However, when a 14-year-old is using their devices in a manner that is destroying school property, that is breaking into the school's IT system, that is doing searches that the parents do not approve of and that are unsafe, then a parent like Tim Ferriter decides, I have to remove your technology. And when you use it, you have to be monitored. Because as Ronan testified, this is not the first time he jailbroke a school laptop. It happened at his school in Jupiter. It happened at his school in Basis. He broke into the IT system at Immaculate Heart. This is a consistent pattern, and you can't break school property, right? Someone has to pay for that. Someone has to answer for that. And what never happened is that Tim Ferriter called the police or told the school, take my kid to jail for committing a crime. He said, I'm going to handle it myself. And though he handled it very poorly, as you'll see here, there was a reason for everything that he did. And so we're going to watch these videos, which were showcased to the state, so that you can see what they presented and then previously what was the context to what happened. Because as you'll see, it was not about stealing candy. It was about stealing an eye touch that did not belong to him.
You want to tell me something? Stand up. Tell me something? Don't tell me what. This is your one chance. Don't look at me like an asshole. You want to tell me something or not?
I have a nightmare.
Yeah, from where?
Blue bed.
Where?
Green bed.
Excuse me?
Green bed.
Stealing again? I mean, really?
What the fuck is wrong with you?
You're stealing,
so fucking
like,
disappointing.
chocolate, and you got so much stuff in your
You're
room.
fucking great. You're just such a disappointment. You're gonna lose. I'm gonna take you out of that school, and you're gonna be in this room.
He's gonna be.
You're this close, because I can't trust shit you do. I'm gonna put the ankle bracelet back on, and then you can try to fucking run away if you want and do all the bullshit you do, but I'm gonna lock your ass down.
You guys are from a toy.
Give me a fucking break.
Why are your little tape?
I'm sick of the bullshit. You're a big boy, you're gonna steal, you're gonna talk to the police, I'm gonna give you a fucking real deal, okay? You're gonna steal from our fucking house?
Again?
Give me a fucking break. What other shit do you got in here?
Nothing else.
Because you're gonna lose it all in about 2 seconds. Lose every fucking
It's
thing.
all gonna
All
be
this
smashed
shit.
real
Don't,
quick.
I told you not to unplug that fucking thing, right?
Yeah.
Do you listen to me?
Yeah.
Bullshit, do
No,
you
you
listen to me?
didn't. You
just
told
unplugged
it to plug this in, and then you're just a liar, Ronan. Just keep lying. You lied earlier when I asked you. You can't.
Fucking disappointing. You're a big boy, you're gonna steal, you're gonna talk to.
Throughout their closing argument, the state, when showing you some of these videos in Tim's own statement, says that's malice, that's anger. This is how maliciously is defined: wrongfully, intentionally, and without legal justification or excuse. It later says that the primary purpose of the acts was to cause the victim unjustifiable pain or injury. In every video that you see in this case, you will see that there was a reason for what Tim Ferriter did. And you will also see, in light of the context in this case, that that moment that you saw, those 6 weeks, are a pinnacle of frustration, right? That tone, that frustration that you are hearing is after years of continuous efforts. I want to talk next about the child neglect instruction. In the instruction, one of the things that the state has to prove is that the parent did not provide care, supervision, and services necessary to maintain Ronan's physical or mental health. The state talked about the child neglect instruction briefly. In this particular case, we can see, so for example, the state said that there is no record of any treatment after 2019. As we discussed, that's not the case, and that's not what Dr. Rappa testified to. In fact, Dr. Rappa relied on medical records from about 2019 to 2021, where Ronan was being taken routinely to the doctor. Dr. Stuart Graham testified that there's no evidence of malnourishment. And the reason we felt that was important as the defense is because of this ongoing discussion about control over food, which, as you saw from the videos, is not consistent with the facts. When he was in trouble, he would be given food in his room. He even said, when we talked about the meals, he said he got the peanut butter and bananas on bread, and he said he was a pescatarian. And so I said, so you were given a meal for a pescatarian? And he said, yes. When you watch the videos, you'll see that the family is eating, Ronan is out with them, and there are times when he's in trouble and he has to eat in his room. You'll also see that the other kids are not eating around the table without Ronan. Everyone's grabbing and going and running like any family. We talked about his ability to manipulate the air conditioning and how that's not neglect, that there was a safety concern there after he almost started the electrical fire. So now we need to talk about whether or not there was a valid legal reason to what happened. And this applies very specifically to the unlawful caging element of aggravated child abuse and to false imprisonment. So under the law for false imprisonment, I want to read it to you exactly. It states as follows: that you forcibly, secretly, or by threat confine, imprison, or restrain Ronan against his will, and that you had no lawful authority to do so. Parents do have lawful authority to contain their children.
Sustained, the jury will rely on the court statement of the law and not counsel's statement.
When a parent has a child, right, a really young child who has to, we're talking about a toddler here, and I don't mean that in a derogatory way. When you have a child who can't be trusted, right, they are contained. And as a parent, you do have a right to put your child in a timeout. You don't have a right for it to rise to the level of abuse, and I'm not trying to suggest that at all. What I am saying is that a parent can make a decision that the safety of that child, and in this particular case, Ronan is running away, as you saw from Tim, who was saying, "You've got me forever, but you have to stop. Because if you keep running away and you keep lying to people about who you are, you're going to get hurt in this world." You have the ability, and that's why it's lawful authority, to say, you cannot leave your room.
Sustained.
As to the unlawful caging, that parental affirmative defense applies to the entirety of aggravated child abuse. So when we're talking about whether a parent's actions...
I'm going to overrule that based on prior conferences that the court had with both sides on jury instructions.
applies to the entirety of aggravated child abuse, that parental affirmative defense. And so the decision that you're making is not, would I have done that in Tim's situation, but whether Tim felt it was reasonable to do that in light of the unique circumstances
Sustained.
that he was facing as a parent.
All right. Jury's instructed to disregard the last comment of counsel. You may continue, Ms. Moran.
That reasonableness element that you are determining, right, as to what a reasonable parent would do, it is under these circumstances. And the circumstances that Tim Ferriter was facing are different than the circumstances of another person who may be in that chair. The circumstances that Tim Ferriter was facing are important in your determination. Because he had a child who, as Dr. Rappa testified, had no impulse control, wasn't stopping, and who by his own testimony was breaking the rules routinely despite knowing that there were boundaries. And these are not just minor incidents. The state can pinpoint a few minor incidents, but the reality is that their own expert knows that the child had an attachment disorder. That expert testified that there were no suspensions in the record. That's not true, and Dr. Rappa explained that. Ronan admitted to that in his own deposition, which Dr. Rappa relied on. This idea that the behavior was so minimal that it didn't matter couldn't be further from the truth. There are doctor's visits as early as 2017, when Ronan was probably 8 years old, documenting, as Dr. Rappa testified to, uncontrollable tantrums that are consistent with having an attachment disorder, of harming other kids at school. There are school records that Dr. Rappa testified to saying this is getting dangerous and it is not stopping, right? That's what she said. It's that lack of predictability and the persistence that is really important in understanding the circumstances that Tim Ferriter had. Because those are the only two things we can rely on, right? Is that when you ask someone to stop doing something, they'll stop. And that when you, and of course it's a little different with a child, you give them a little bit more room to grow. But there comes a point where that stops too, where it's becoming dangerous, where they're not allowed to run out of the house in the middle of the night, where they're not allowed to steal knives from a location where the knives do not belong to them. The fact that they did not utilize the knife doesn't matter for a 10-year-old. You shouldn't have knives. The fact that you are doing searches on your computer for violent things. You're not allowed to have access to computers if you do that. So those circumstances are unique to Tim Ferriter. And that lack of predictability Dr. Rappa talked about, right? We expect people to act in a certain way. And the thing about that impulse control and lack of emotional regulation is that there is no expectation with Ronan. There are good days and there are bad days. And you see that in the video. There are days where he's hanging out and nothing's happening. And there are days where he is so frustrated, he is screaming in his room. Those good days and bad days are consistent based on what Dr. Rappa and Wade Myers testified about with someone with that attachment issue or complex PTSD. That both admit the Ferriters didn't cause. And behaviors and issues consistent prior to 2018. After I am done, the state has the opportunity to have a rebuttal. I do not have that opportunity. This is the last time that I have to talk to you. And so I want to discuss again reasonable doubt. Before I do that, I want to talk a little bit about, the jury credibility instruction. You heard testimony from Fiona, and the state talked about how it was consistent with what Ronan said. What you will recall about my colleague's cross-examination of Fiona and also mine of Ronan is that there were things that were either not remembered or misremembered. And I don't think that these kids are lying. I think that Fiona is a teenager who has her own life going on and doesn't always remember and doesn't know everything that happened with Ronan, right? Her parents are not telling her every single thing. Mr. Wahed asked her about specific acts that had happened, and she didn't know about them. She also said that he never went to a marching band practice, and we were permitted to admit this exhibit showing Ronan at her marching band practice, that he was never permitted to do homework in the house. And there he is doing homework with her in the house. And the state can say all they want that, oh, these, minimal incidents, they don't minimize this, that, or the other, but it does challenge the credibility of the witnesses. Because Ronan initially said that he never got food, that he occasionally was fed in Florida. You can see on the videos that's not the case. You can also see that when I questioned him, I went up to him with his deposition and said, look, when you were in a deposition and sworn under oath, you said you got every meal. And he said, that's right, I agree. So at the end of the day, these are children. And the best evidence is going to be the videos that you see. And I encourage you to watch that 14-hour video as best you can during the course of this. So now let's talk about reasonable doubt. So the instruction that you will get and the judge has read to you, but I want to highlight a portion of it, is this. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after considering carefully, comparing and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. Reasonable doubt is one of the early terms that we learn about in our civic education, our legislature, and here's why it's so important. This is a decision that is probably more permanent than every important decision you have made in your life. You will go back there as jurors, you will come to a verdict, and that will be it. If you get married, you can decide to have a divorce.
Sustained.
This decision is one that you cannot change, unlike many decisions in your regular life. And that is why we have an instruction that says if you waver and vacillate, if you think, you know what, he shouldn't have done that, I think he might be guilty, but then in another minute, you're like, there was a reason for this. I think that affirmative defense applies. You must find him not guilty. If you think he might be guilty, you must find him not guilty. If you think he could be guilty, you must find him not guilty. And the one thing that I am telling you is you do not have to like Tim Ferriter, and you do not have to like what he did, because what he did was wrong. And he will have to live with that for the rest of his life. When Ronan testified, he said, Tim and Tracy were just acting out a frantic surprise of my emotions. And he said, forgive them and move on.
Sustained.
That is his testimony. And so when you are back there deliberating, understand that Tim Ferriter made bad choices and you do not have to agree with them. But whether or not what he did amounts to a crime under the law is a different question altogether. And it is one that the state has not proven. I'm asking that you find him not guilty.
Thank you, Ms. Murad. Rebuttal? And Ms. Murad, just hand Ms. Black the microphone. Thank you. You may begin, Ms. Black. Are you going to be using the? I'm not. All right, you can go ahead and cut it off then. All right, thank you.
Defense just got up here and told you that the horrible act of parenting is not a crime. But in this case, it is a crime. Because it's about what a reasonable parent would or would not do. Because what Tim Ferriter did was not reasonable. Now, defense got up here and talked about the horrible things that Ronan Ferriter did, the dangerous things that he did, the reasons why he had to be locked up. But you have to remind yourself, these are things that he did when he was 11 years old. He is a child. He is in elementary school. Kids in elementary school will get in fights. Sometimes they'll go ahead, make jokes. He decided to go into his sister's classroom and tell the class that she was lying, made her cry. He decided to get into a fight with another child. But none of these actions amount to the treatment that he got from the defendant. Because you have to put it into perspective. These things happened when he was 11, 10. Yet when he's 14 in Jupiter, Florida, in that box, that's why. Because of the things that he did when he was 11. They talk about how the behavior was escalating. But what behavior? The lying about stealing chocolate? The bad attitude that he had when his father put his hands on him, threw him on the bed? The bad attitude that he had when he was throwing his Legos around, taking off his posters because he didn't know how to handle the trauma that the defendant caused him. That was the bad attitude that he had. Now, defense also spoke about how Dr. Rappa had records of after the fact, how in 2022 there was a neuropsychological done. But you also have to remember that this evaluation was done after the defendant had been arrested for these charges. You also get to take into consideration the fact that it is a self-reporting evaluation. That the things that Ms. Ferriter told the doctor, those are the things that she wanted to tell the doctor.
Overruled. Overruled.
Dr. Rappa also talked about that in this evaluation that there were changes, there were certain levels in his inhibition, his emotions. But she also testified that this is because of the way that the defendant treated him. She got up there on the stand and said that this is not malicious. This is just how they had to deal with it. This was the end result, not malicious. Yet, she never spoke to the defendant. She never interviewed him. She never got
I'm sorry? Overruled.
the chance to find out. And for her, it was pure speculation as to why. The biggest thing here is the criminal intent. Now, we already talked about this in jury selection. What does intent mean? A lot of the jurors would say words, actions, past behavior. And that's what the state has presented you with. We have presented you with the defendant's actions, his words, his behavior towards Ronan. Because it's the intent to do these things. Under the aggravated child abuse statute, under the instruction, there's 3 different ways. It doesn't have to be each one. It's not an and. It's an or. That he was unlawfully caged, or that he was maliciously punished, or that he was unlawfully and willfully tortured. And we have presented evidence of all 3. You might go back up there and say, you know what, I don't think that they prove that he maliciously punished him. But he did unlawfully cage him. And that's still guilty of aggravated child abuse. There is also, the defense also brought up the fact that Ronan was explosive, that he was violent. But there was no evidence of that during that 6-week period in Jupiter, Florida. If you see the videos in both the state's videos and the defense videos, he was docile. He seemed nervous around his parents. At one point in the defense videos, he's standing next to the couch while his father's watching TV. He doesn't know whether he should sit down or not. He doesn't know how the defendant's going to react.
Sustain.
But eventually, you will see that he sits there and he'll look at the father's reaction.
Sustain. I mean, excuse me, overruled on that.
You will also see in some of the videos how he acts in the room, that he's withdrawn, that he doesn't have that stimulation. I know defense got up here and showed you January 5th. That was the big picture. He had his Legos, he had his desk, he had his bed, he had everything. But throughout each day, there's less and less and less. They try to say that this was the result of a timeout. But we all know that from Dr. Myers, a timeout is not a long duration of time. If they wanted to call a timeout, it's a timeout from January 5th, 2022 to January 28th, 2022. Again, not reasonable. Defense also brought up that this was a natural response to control the child. That if a child stole a car, what do? You take the keys away, you take the car away. And that it's not taken to the extreme. But making a child go to the bathroom in a bucket, that is taking it to the extreme. They said that they wanted to lock the door at night because they were scared of him running away, scared of him causing harm to himself, scared of all these things would happen to him. But there was no evidence of that. He couldn't leave the back. He had degraded and dehumanized. and use that bucket. Not only that, but you saw in multiple videos that the animals had the freedom to go around the house. Yet he was the one that was locked in that box.
Overruled. Jury can rely on their own understanding of the evidence that was presented and published to you.
In reference to the violence that the defense was talking about, there was only 2 times that was brought up. And that was in Arizona, in which the defendant's not being charged with. We're specifically talking about a time frame in December of 2021 to January of 2022. They also brought up that they had to keep Ronan in this box because it was this way. That's what they had to do. They had no other option. They had no other choice. This is what had to be done in order to protect them. But you know what else could have been done? The medicine, the therapy, that could have been done. Both experts testified that there were only a handful of times that Ronan had gone to a mental health professional. One of the experts testified that there were about 2 or 3 30-minute sessions. Is it reasonable to think that in 2 30-minute sessions, the problem is going to be solved? No. But the defendant, the solution to that is putting that kid in that box. Not trying to find other providers, not trying to find
Overruled.
different medications that may have worked for him. But no, that was their solution. Both experts also testified that this was not the proper solution. This is not what you do when you have a child with these issues. This is not what you do when you have a child that just wants to be loved, that wants to be part of that family.
Sustain. Move on. Jury is instructed to disregard the last comment of counsel. You may continue.
There was
Ms. Black.
also a comment about Dr. Myers not watching all 21 videos. Yet Dr. Rappa did not watch all 21,000 videos either. And again, they went to some doctors and then it stopped. They didn't follow the advice. And again, no doctor told them.
Overruled as to that. Again, the jury is instructed to rely on your own recollection of the evidence in any determination you make.
The biggest thing here is that the crime occurred in the only space that Ronan had known for long periods of time. The state never made any allegations that he was in there 24/7. The state never said that he had never left his room. He did. But you have to also look at the fact that the only time he left his room was when there was a parent around. When they told him, you're allowed to come out. When they told him and they would stand there and follow him out. Those were the only times he was allowed from the room. There was also times that he did not control the light. It was the defendant who would control the light, whether it was on during the day, whether it was off during the day, whether it was on at night. He also controlled the air conditioner. There testimony in the videos that the defendant did not want him touching that air conditioner. Even at points where Ronan says it's too hot. Still, I know defendant started about the to the abuse and to the of child abuse. There is no evidence there. Because what the defendant did was not reasonable. It was not reasonable to lock him in a box. It was not reasonable to leave him in the dark. It was not reasonable to take light away from him. It was not reasonable to leave him in the room with no air conditioning. It was reasonable to make him pee in a bucket. There was no legal justification for any of this. And because of that, you should find the defendant guilty of all 3 counts. Thank you.
Thank you, Ms. Black. Let me have counsel approach, please. Typically go no later than 6 p.m. on most days. And if the jury is not able to stay until 6, then we usually end at 5 on days that are where jury deliberations are actually occurring. I never know how long deliberations are going to occur, but I do like to give my jurors some idea of what the normal workday is once deliberations start. So for you, then the process will be pretty much the same as it's been up to this point. Go home, relax, have a good dinner, good night's rest, because tomorrow will be a full and long day. You won't be out here in court. You will be in the jury room deliberating, but that will be a process that you'll experience firsthand tomorrow. Remember, during the break, don't discuss the case. You know everything about the case there is to know at this point, so more than ever, make sure you don't discuss the case with each other or with anyone else, or do any kind of research, investigation, or any of the number of things that I've instructed you during the course of this trial not to do. The last thing I'll tell you is make sure you don't inadvertently expose yourself to any media coverage of this, including video or print coverage at this point. Other than that, go home, have a good evening, and I'll see you tomorrow.
Okay, so we're on verdict watch. Now, just whenever, but they're not staying tonight, it looks like. Yeah. Hi, legs. Yeah, as far as tomorrow, I don't know. I think we'll just go live as soon as we get we'll go live as soon as we get a verdict. Yeah, last time I said it was going to be that night, and it was. Oh my God. But they stayed. See, these guys aren't staying. I was going to show you guys really quick. I think at some point when my computer was acting up, it said something about yeah, they'll start deliberation though tomorrow. They won't be in the courtroom like you just said. I don't have any breakdown of the jury. Let me try to find that. That's a good idea. But at one point when my computer was acting up, it said something about my about the streamer. Now, for some reason, this is weird. What's the matter, baby? This is weird. All of a sudden, I wasn't automatically signed into my deal. Oh, well. I was going to show you guys this thing for Beezer that I'm working on. Come here, baby. My little baby just woke up from a nap. There you go. There you go. He's okay. There's only 6. They did not release the alt. Huh. Oh, sweet baby. Yeah, they won't be in that room. They won't be in the courtroom though. They'll be deliberating. Not that. Not that one. What? I thought it would let me show that. Judge mentioned the jury is only 6 members and that the alts have to be there tomorrow too. Huh. So this, I've already flipped it and I've already taken it apart. So what I'll do, I'll put it up. I'll show you what it once, because these are all going to be different colors and be layered. So I'm sorry, I got my hands full here. What did I do? Okay. So the one that I brought over here is this one. So without those all taken apart, hey, so do you see what this is going to look like? Like that. So I'll put the different, those will go together. And then, so on the front of the shirt will be that. And then on the back, I'll put her name or whatever you think. And then on the cape, I'll have all the different channels with the YouTube logo. Yeah, these days it might have to say something else, huh? Like, cram it in your cram hole, people. Evildoers. For Beezer. So, Tragic said she wanted a cape. She wanted me to put the channels that she mods on cape. So I got a cape, and then she can put the cape on or not. So I was going to put, and she said she thought Superman because of the cape. So I'm thinking, I was thinking Wonder Woman is better than Superman, right? So I'll put just her name, I think, on the back of the shirt. Yeah. So I think so. If anyone has any ideas, just tell me. I think, yeah, I like Wonder Woman better. And this, well, I wasn't sure because, putting that globe back there, that's more like, because, she, hey. So it's like she's an international mod, right? Like she mods for, she mods for people in other countries too. Just saying. I mean, I don't know if I know Becca Lynn's in another country. So there's that. There is that. What oh, I don't know what oh. Cheese It Chick. Oh, yeah. Where did that come from? Oh, okay. Hello, Mohawk Mom. Oh my God. Oh, I didn't see that. Oh, that's good. I hope she does go to jail. Leg her abduction on the side of the road. Let me see if I can get a makeup of the jurors. Oh my God, Jack, that is not going to fit. Jury has been seated. I'm not seeing it. I'm not seeing it. Okay. Okay. All right. I can't find. Hello, Ryan. I don't understand if she has to, why did a judge find her guilty? Yeah, Julie, I have the list of people she mods for. I actually have those all done. Let me see. Let me see. Oh, wait, no, I need my stuff. The names that I have. Bombshell Reloaded, Jilly from Philly, The Masked Angel, True Crime Latest, and Tragic. All right, stop. Tragic, Becca's Little Nook, Miss Moz, and Angie Uploaded. Does anybody know of any other ones? By any chance? How are you, Ryan? Oh my God. Ugh. This little boy. What? What, my little baby? Our little baby. I'm doing good. And now all of a sudden okay, good. I need to make some lunch for this boy. He just woke up. And I need to pick his nose because I can hear his loud breathing and I don't like that at all. He doesn't like me to pick his nose, but yeah, I gotta go too. I gotta go and take care of this boy. I will come on as soon as as soon as the verdict comes in, I'll just go live immediately. As soon as they say, so we can go in and watch it. And right now, after I get off here, I will check my StreamYard, see what's going on there. Alrighty, dighties. So I will see you here as soon as we get that. And everybody have a wonderful night. I expect this will happen early tomorrow. My idea. So anyway, thank you so much for hanging out. Thanks for all your patience with my nonsense today. I'm really sorry. I will try to work on it. And thank you very much. I love you very much. And shut up, Hondorcas. Night, everyone. Bye.